Okay, welcome to Chapter 11. This chapter serves, as a little bit from the previous one, as a bridge between our discussion about the court system and moving over towards the correctional system. So here we're really going to look at some of the legal aspects behind and some of the criminological aspects behind what we do when we have a conviction and moving it over, as I said, towards correction. So a few quick questions to ponder as we look at these. And, as I discuss in class, the purpose of college is, of course, to provide you with information, because some of this information will be new to you, but also to get you to think, hopefully think deeply about some of the facts and some of the your reactions to them that you've had, and make you question what you know or what you think you know. This is not to say I'm trying to get you to change your mind. Sometimes you ask questions so that you can more deeply understand what you know. And this can lead you to new insights and more effective behavior. So one of the questions to ask here, of course, is why are we punishing? Why is it necessary to punish someone? Is punishment itself a goal? Is it the end thing you want to accomplish? Or is punishment really a mechanism that you're trying to accomplish some other goal for? If you just say, well, I want to put someone in jail, that could be, if you're ending the conversation there, the end of the conversation. But then you could go further and say, and this is why he is in jail. This is why I want him in jail. This is what I hope to accomplish by putting him in jail or prison. Next thing to kind of keep in mind is what is effective punishment? Of course, presupposes we can define effective there. And does effective punishment vary between persons? And this is going to really bring up the whole issue of discretion and disparity. What alternatives are there to incarceration? In an earlier iteration of this course, I had students read excerpts from a book written by a somewhat prominent academic about why corporal punishment might be explored as an alternative to incarceration. So would corporal punishment is the infliction of physical pain, would that be a better alternative than locking someone up for 5 or 10 years? And if not, why? I mean, and I'm not saying it is. Again, I posit these questions not to get you to accept any conclusion I talk about, but to get you to ask, okay, well, why incarceration? Why in the 1780s or 1790s did we start to go towards incarceration and away from corporal punishment? Should everyone's punishment be the same? If a 85-year-old administers a fatal dose of morphine to her husband who's suffering in agony, thereby committing first-degree murder, should she suffer the same penalty as a 25-year-old who stabs her boyfriend in a fit of rage? Both men are dead, the boyfriend and the 85-year-old husband. Should punishment vary? Does it matter who the victim is? Does it matter what the crime is? How do you rank crimes? Does it matter about the gender of the victim, the gender of the offender? Does it matter about the age or the mental status? All of these things, I think, by examining them and keeping these questions in the back of your mind, really help us explore punishment and corrections in a, I think, a more rigorous way. Okay, we'll skip all those learning objectives and talk about your book's first attempt to offer the rationale for punishment. So it offers really 4, and again, whenever a book or a professor or anybody says there are 3 reasons for this, usually there's more than 3, or in this case more than 4. But these are the ones that your book chose to highlight as prominent. There are others, and we're going to talk a little bit about some of the others. So some of the possible reasons for punishment. Retribution. This is a very old one. This is, if we use the King James biblical discussion, an eye for an eye, a tooth for a tooth. This is very, I guess you could call very Old Testament. Those who commit criminal acts should be punished based upon the severity of crime, and that's all you consider. And you essentially get your just desserts. If we want to step away from Christian imagery, you're going to balance the cosmic scale, the karma of it. Second idea, and we'll explore this actually in a little bit greater detail in a bit, is deterrence. You punish to prevent future crime. Incapacitation, your punishment is designed to remove this individual from the society, to separate him from the community, in many ways to label him as a criminal and not as part of the greater society. And finally, and this is something I think in the mid to later 20th century became very important, rehabilitation. To take these people who are misbehaving, sometimes in very minor ways like truancy or smoking, sometimes in very severe ways like sex crimes or murder, and eliminate from their behavior these bad actions or these bad trends, to fix them, in other words. Okay, now some of the more recent ideas behind justice, and this is an alternative, and we're going to talk about some alternatives, is what's called restorative justice. And here what you're focusing on is you're pulling back from the single individual event, and you're looking at how the crime has harmed both the victim and the community within which the crime has occurred. So some of the differences when you look at restorative justice as your rationale for what you're going to do, your punishment, is you try to get the offender to accept responsibility. You try to more deeply involve the victim in it. Often in restorative justice processes, the victim and the offender meet so that the offender, and not just meets in the courtroom when there's a testimony, but very often they meet face to face, and the offender is confronted with the damage he did. The community is also involved, and you seek solutions to the problems that maybe caused the crime. So if you had someone you caught vandalizing because the youths were bored, then they would meet the person whose property they vandalized. The community would be involved and say, okay, well, the immediate reason here was this boredom. What can we do? Can we provide an alternative to running loose? I said I was going to get back to deterrence, and deterrence is very frequently something that Americans in particular talk about, and there's really two types of deterrence: general deterrence and specific deterrence. General deterrence is when you punish someone as an example for the greater society. So if someone steals a bicycle, or if someone breaks into a house, you punish him so that nobody else gets the idea that they should steal bicycles or they should break in the house. And the rationale behind this is people in the future will not commit crimes because they see this. And people commit crimes because they decide to do it. It is a rational choice. And remember, when we talked about some of the early criminological theories, I said America has very much embraced the idea of rational choice. Why did Peter rob the bank? Because Peter chose to rob the bank. Now, in this idea, interestingly enough, publicity of punishment is very critical, as well as certainty of punishment. So this would be, for example, a strong argument to say that we shouldn't, if you take the most extreme type of punishment, most extreme type of deterrence, you shouldn't have executions in private. Capital punishment should be practiced in public. It should be seen. If you're going to say that by having capital punishment you stop murders in the future, then everybody should see the executions. Now, specific deterrence is a little different. Specific deterrence still looks to the future, but the punishment is supposed to keep that person who committed that crime from repeating it in the future. So as opposed to be focusing on everybody where you'd want maximum publicity, it's focusing just on the offender. Okay, what are some alternative reasons, maybe things that your book did not address that we could talk about, other reasons for punishment? One is you can create a system of laws and punishment for violating those laws because you want to maintain the current social, political, and economic order. And punishment reinforces that you can't do this. You can do this behavior, but this behavior is wrong. This behavior supports society, this behavior attacks society. Another possible alternative reason for at least our current structure is that punishment can be profitable. You will sometimes hear the term prison industrial complex. The criminal justice system exists to punish, but private groups can use this methodology of punishment to make money. And they do this by prison labor. The 13th Amendment of the Constitution of the United States abolished slavery in the United States, but it had kind of a little asterisk in it. Basically, it said, and I'm paraphrasing the 13th, we're going to abolish slavery unless you've been put in jail. So they used involuntary servitude, but it allowed compulsion to labor if you are a prisoner. Now, how common is this? Well, if you're in, if you look at the uniform, this is a good example, that an American soldier wears. A lot of that uniform, his helmet, his rucksack, the old days, if you want to use an old term, the belts, the pants, a lot of that is manufactured in prison. So American industry will go in and they'll say, okay, we will pay these inmates, and we'll pay them very, very small amounts of money, $1 a day, 20 cents an hour, some ridiculously low number. This allows them to compete against the alternative of, well, we would have to have these American uniforms made in Vietnam or in China or in Taiwan or Korea. Instead, since you don't have to pay even the relatively low minimum wage of $7.25 an hour, $7.35 an hour in the United States, you can pay $1 an hour or $1 a day. Punishment also has a psychological benefit. One of the ways in which you establish the ability to punish is that you ostracize, or the psychological and the sociological idea is the idea of the other. It's easier to fight a war against people that you don't know. It's easier to punish people that aren't like us. So punishment says these people are criminals. We can punish them, we can ostracize them, we can push them out of our society. They're not like us. We're good. They're bad. And we can tell that's because we're punishing them. I include this slide. It's one of my favorite slides. And believe it or not, yes, that's an elephant, and yes, it's being hung. And I like this. It's somewhat comedic, somewhat tragic, somewhat horrific. In 1916, an elephant in Tennessee killed its trainer. So they decided to punish it. Well, think about this. You're punishing an animal. The good people of Irwin, Tennessee hung it. That is a railroad crane. The first crane they got to hang it broke, so they had to get a bigger, more industrial crane. Then they put a steel cable around it and they hung the elephant. Now, this is obviously a deterrent, a complete specific deterrent. This elephant will never kill anybody else, this elephant. Now, you could argue that it was a good general deterrent. We haven't had a lot of elephant killings in Irwin, Tennessee since then. You can also say that, we will, and we'll do this with animals. And this is a good idea about the other I was just talking about. We will put dogs down that bite people. We will kill animals that are seen as a threat to humans because they are others. They're not us. And when you can claim that a person, and sometimes you'll hear people who commit terrible crimes, you'll hear them described as not even human. That's not even human. That allows you to hang the elephant. It allows you to treat them that way. All right, the structure of sentencing, the legislative. Often a legislature like the North Carolina General Legislature, will decide a range of time to be served. So they would say, you can give a sentence between 5 years and 10 years. Or, as an alternative, they might say, you've got to give a sentence of 70 months to 80 months, period. We're not going to give you a lot of options. Now, of course, you have to control people in prison. And if you put someone in prison and you say, you are going to serve 5 years, you're going to serve 60 months, no matter if you're good, no matter if you're bad, no matter if you cooperate or don't cooperate, whether you work in these factories we have inside prisons or don't work, you're serving 60 months. Well, good luck controlling that person. Because how do you get them to do something you want them to do? How do you get them not to fight? How do you get them? You essentially have to give them some incentive to behave or some way in which you can punish them if they don't. So typically, there is a minimum maximum time given. And there are other options. I'm going to get to structured sentencing in just a little bit, but there are other options here. Fines are very, very common, and these have been escalating in the last 10 or 20 years. Last time I was down in district court, you could have someone that got a speeding ticket, and the statutory ticket might be, okay, this is a $50 fine. And people would say, okay, well, I can pay a $50 fine. And then they would give you court costs. And a court cost in Wake County are over $250. So you might get a $50 fine, but then you'll also get a $250 bill for the court costs. And in that court costs are things that the government wants to do, but doesn't want to impose taxes to do. So they might want training for law enforcement. All right, well, we'll put a $15 surcharge as court costs. They want a retirement plan for the sheriff's department. Okay, we'll put a $30 court cost. This isn't going to show up as a tax, so you can run and say, oh, I don't tax people. But you are going to have money to do things you want to do. So fines and court costs are very, very common. Probation, this is by far the most common. We're going to talk about that. Incarceration, either in jail for a misdemeanor or prison for felonies. Death, pretty rarely implied. And some unique options, alternative sentencing, which, again, pretty rare. Okay, before this goes on, and we're talking now for felonies, we're not talking for a misdemeanor. If you jaywalk, we're not going to do a pre-sentence investigation report. But if you had someone, let's suppose you had a 14 or 15 or 16-year-old that had been tried as an adult for assault with a deadly weapon, very serious crime. What would happen would be a probation officer, before he was sentenced, before his conviction, would go out and prepare for the judge a record, a pre-investigation record. Okay, here, and they would say, oh, this is a straight A kid. This was a kid that just lost his father. This was a kid that had been assaulted just the week before. This was a kid that worked 40 hours a week to support his family. All this great information that would make the judge say, this wasn't a bad kid. Or flip it. This was a kid that had been in trouble all the time. This was a kid that was in a gang. This was a kid that stole and didn't support his family and abused his family. So all this information, some of which wouldn't go into court because it wouldn't meet those big three gatekeepers we talked about last week of relevancy, competency, and materiality, would be provided for the judge. And then he would use that to guide his decision as much as he could. So what impacts what kind of sentence you get? Well, the big thing is, how serious is your crime? Obviously, whatever we deem to be a minor crime, such as speeding, gets a low sentence, and what we deem to be a serious crime, like rape or murder, kidnapping, gets a high crime. It's serious. Even if you have two fairly similar crimes, let's say kidnapping, some kidnappings are deemed to be worse than others. So let's take one that would be worse. Let's suppose you kidnap someone, okay, which would be a serious felony, depending upon the degree, might call for 5 years or 10 years in prison. But let's suppose you didn't just kidnap someone, you tortured them. when you kidnap them. You rape them. You physically maim them when you do this. And then you buried them in a shallow grave and they only escaped by accident. Those would be horrific additional pieces of information that, because they are deemed to be aggravating, would call for more serious punishment. Now, mitigating acts, you kidnap someone, but you didn't harm them. You treated them well. You protect them from others who were trying to harm them, and you release them in a safe location. In fact, in North Carolina, one of the differences between first-degree and second-degree kidnapping is, did you release them in a safe location? And this gives people incentives if they know, well, the worse I am in committing this crime. Remember, we believe in rational choice. The worse I am in committing this crime, the harsher my penalty. Or the nicer I am, the less penalty. Something else that impacts judges is, what is their personal philosophy? Where are they coming from? Are they interested in rehabilitation? Are they interested in punishment? Years and years ago, we used to have a district court judge called Jerry Leonard, who really took a lot of time for juveniles. If you had a juvenile case, Judge Leonard would hear you out, would work to minimize the negative consequences, would be concerned about rehabilitation, but would not be concerned in punishment. Now, he's not on the bench anymore. It used to be Joyce Hamilton took over, but you can also have judges that are like hanging judges. They're just like, I want to punish. I want to drop the hammer on people. So you can have the difference between those two. All right, what about North Carolina? Because as I've told you, this course tends to focus a little bit on North Carolina more to give you an idea, because most of you are going to live here. And since the 1980s, North Carolina has been taking away the power from the judges. It was really seen that either judges were too liberal or too weak, or they weren't being fair. So the general legislature said, well, we're going to set the sentences. Now, I want to emphasize here that when you say, if you've got 3 or 4 components in a system, like the police, the courts, the prisons, and you take power away from one of those, the power continues to exist. The discretion continues to exist. You're just moving it to a different location. So when we created structured sentencing in the 1980s, we did not get rid of discretion. We simply said, we trust the people in the General Assembly to make the right discretionary decisions more than we trusted judges. And I'm not so sure that's a good idea, but that's, again, something for you to think about. So we created a matrix, a grid system, which I'm going to bring up for you in 1 second, in which the first thing we did is we categorized felonies from A to I. So it's A, B1, B2, C, D, E, F, G, H, I. Any felony you commit is going to be called one of these. So, for example, the worst of the worst, first-degree murder, is an A felony. And then really, really minor crimes like assault. Assault could be a misdemeanor, but let's just, very, very minor crimes will be Class I. It also created aggravating and mitigating circumstances that they defined. So, with no more ado, let's go and take a look at the chart. Now, you may want to zoom in on this slide. This is the North Carolina structured sentencing slide. These are this has been in effect for the last 5-10 years or so. So the first thing we do, if you can see here on the gray part of the slide running down, we figure out what your felony is. So let's suppose the felony you committed, say it's a kidnapping or assault with a deadly weapon. Let's just suppose it's a Class D felony. So you come in my office, you've been charged with this Class D felony. I say, okay, you got a D. What did the general, and then the next thing I'm going to do is I'm going to, if you look here at the top, I'm going to determine your prior record level. Now, in fact, we have a worksheet you can do that with. And to use that worksheet, I need the basic, most important thing is I need your criminal record. So I will get a copy of your criminal record. I'm your attorney, so I'll get a copy of it. And if you have no prior offenses, none whatsoever, you would be level 1. So this is 0 points to 4 points, to 1 point. So it would be right here. Now, all things being equal, if we don't look at the aggravated or mitigated, that would mean that if you went to prison, you would serve between 51 months and 64 months. Right here, 51, this is a D, to 64. Now, if you were particularly heinous, let's suppose you was assault with a deadly weapon, inflicting serious injury. Let's suppose that you maimed them, you put out their eye, and you did it for sport. We would say, wow, that's really bad. You've got no other mitigating factors. We're going to bump your sentence up between 64 and 80. On the other hand, let's suppose that you treated the person that was injured and you waited and cooperated with the police. We would say, well, those are mitigating factors. We're going to bump it down to 38 to 51. So your sentence, and that range, again, that range is there to control you. We're going to give you 51 to a maximum of 64. That range is existing so that if you behave in prison, you'll get out at 51. If you don't, you'll get out at 64. So looking at that range, the worst possible scenario, you go to prison, you're really bad, a lot of aggravating factors, 80 months in prison. Okay, so a little bit close to 8 years. Oh no, 7 years, excuse me. If you had cooperated, were good, didn't harm people, you'll notice that the lowest possible is 38. And that's behaving in prison. So it could be twice as long. This is only about 3 years, 3 years and 2 months in prison. All right. Sentences can vary. We can have sentence disparity and we can have sentence discrimination. And these are related concepts. Disparity is when you get people who are convicted of the same or similar crimes, but you get different sentences. This is not necessarily a bad thing. It's not necessarily a good thing. Again, the example I used at the beginning, as I said, if you had a loving spouse who helped someone end their lives, not to get money, but to put them out of their misery, that's a sentence. I mean, that's a first-degree murder charge in North Carolina, believe it or not. Versus if you had a gang member who stabbed someone as part of initiation and then twisted the knife in there and, took a trophy, cut their heart out. I mean, that's horrific. They both committed the same crime. But would you say that both of them deserve the same sentence? So, what factors will lead to disparity? Well, this is discrimination. Now, some of these factors are okay. Some of them we say, well, we're going to list, when we go back to North Carolina, they will list aggravating and mitigating factors. So, a mitigating factor, believe it or not, in sentencing, someone will get you lighter sentences. Do you support your family? Are you employed? Are you a veteran? Those can all get you lighter sentences. That would lead to sentence disparity, where you get a different sentence for the same crime. But then there's things that are a little bit more questionable. Gender, race, economic class. Some of those, you would say, well, should we consider them or not consider them? And some of them we're more comfortable considering. I don't think most people would say it's okay to consider someone's race. Oh, well, he's Latino, I want to give him a higher sentence. Or she's black, I want to give her a lighter sentence. Or he's white, I want to give him a harsher sentence. Or she's white, I want to give her a lighter sentence. Race we're not too comfortable with. Economic class, they're poor, let's drop the hammer on them. Not something we outside. Gender is one of those things that's closer, which is an innate condition where we will consider. So just consider this scenario and be honest with yourself. If you had a 20-year-old woman who slept with a 15-year-old boy and you had to sentence them into prison, would you treat that sentence different than if you had a 20-year-old man who slept with a 15-year-old woman? Now, in theory, those are equal situations. In practice, at least for many in society, maybe not even you, maybe not even me, we would tend to treat those differently. Okay, different types of disparity. You can get similar sentences for crimes that are very different. So, you can have someone who commits a very heinous crime and gets a very light sentence. A very minor crime gets a very harsh sentence. That would be disparity. You can get two people who committed the same crime get different sentences. And then you can have issues where the aggravating or mitigating factors have too large an impact on sentencing. Sentencing discrimination. So some groups are treated more harshly. And the first one, this is men and women. Women tend to get lighter sentences, men tend to get harsher sentences. This is what's called the chivalry effect. In part, this is, I guess, one of the few, if you're a woman, one of the few good things about the patriarchal society is that if you don't think that men and women are the same in the sense that women have to be protected and women have to be cherished, and those are, I'm putting a positive spin on it. The negative spin in the patriarchy would be those women have to be controlled. Their options have to be limited. But I guess if there's one positive effect that this is, and it's well documented, is that women tend to get lighter sentences, which isn't good for men. The poor tend to get harsher sentences. Minority groups, Latino, Hispanic, African Americans, tend to get harsher sentences. The wealthy tend to get far lighter sentences. So you can have someone like one of the DuPonts, which is a very wealthy family from Maryland, who committed a murder. And he did not get a sentence of 20 or 30 years in prison. You just don't tend to see that. So there is a conflict between the idea, of course, that the judge is the person who should make the decision. And I'll be honest, I'm a little biased here because I tend to think that the person on the spot, the person who's seeing all the facts, maybe should have more power than the abstract group, the legislature, that's sitting in a building sometimes hundreds of miles away and sometimes years away from what's going on. You have to ask yourself the question, who is more subject to improper influence? Who is more subject to prejudice? Should we trust judges to be right, or should we trust our legislature to be right? Now, most states have, including North Carolina, some type of determinate sentencing where we have guidelines. Now, the feds have guidelines, and they are particularly strict. Judges, only in very special circumstances, are usually allowed to ignore these and impose different sentences. And it's rare and difficult. In the 1980s and 1990s, we began to impose in the United States mandatory minimums, where we simply said, no more letting people out, no more, they're going to go to prison, they're going to go to jail. We enacted across the United States 3 strike you're out laws, we enacted habitual offender laws. And what we saw was really soaring prison and jail populations. Now lately, in part because of the cost of this program, and we'll look at that when we get firmer into corrections, the feds and many states have really looked at this and said, maybe mandatory minimums are not the best idea. Also, by the 1990s, we began to turn our focus towards victims. I talked a little bit about victimology, which is the study of the victims in all this. Very often, the victim is the forgotten person in the whole scenario. You have the offender, you have the police, you have the courts. Well, what about the victim? So by the 1990s, they began to move the victim from the periphery of the process towards the center. And one of the clearest places we saw this are victim impact statements. So let's suppose that you have a murder and you have John Doe who was killed. Well, who's going to speak for John Doe? Who's going to talk about his lost life? Well, one of the things that can happen at sentencing is you can have victim impact statements prepared. You can have the family of the victim, either read out or testify to things that otherwise at the trial were not relevant, were not competent, were not material. And they can say things like, this was my only son. This was the only person that ran a vegetable stand in a food desert. This is the only person that would help little old ladies across the street. I don't mean to minimize it. I'm just trying to give you an example of how you can see the greater impact of a crime. And this would allow the victim to play a more central role in determining sentencing. So are there goods and bads of this? There are goods and bads. It allows the victim in the community a voice. It can be a therapeutic, it can be a healing thing for the victim. And if we're going to put the victim at the center, we should be concerned about how they get over the crime. It lets the judge and the jury see the consequences, and it may be very critical in forgiving and healing. Now, there are some cons. It does inject emotion. If you have a very sympathetic victim, or conversely, if you don't, the victim's not very sympathetic, it could lead to a harsher or a lighter sentence. It can allow prejudice and anger to become central issues, and it can reinforce the concept of retribution or punishment, which may or may not be appropriate. All right, now we're going to talk a little bit about the death penalty. Capital punishment is carried out in one of 5 ways in the United States. Electrocution, which is the second most common, I'd say. Lethal gas, which we don't see much at all anymore. Hanging, which is pretty rare. Firing squads, which is rare. You typically only see this in a few states. Utah has it. Famously, I think one of the first persons executed after the reimposition of the death penalty was a man, I believe his name was Gary Gilmore. There is a passage in the Book of Mormons where you atone for sin by the shedding of blood. And obviously, if you're hung or electrocuted or injected, there's no shedding of blood, so you can't atone. So this has been provided as an alternative. I believe it might also exist in some military situations. But by far the most common methodology of the death penalty is lethal injection. This is what North Carolina uses. This is usually a drug cocktail. It's usually at least 2. And what happens is paralytic is administered, where you are unable to move or relax, and then a second drug that will shut down or stop the heart, and you die. We've had some problems with this method. The biggest problem is the drugs that are primarily used in this, the drug cocktail, if you will. The component parts are not manufactured in the United States. The 2 primary countries that manufacture it, last I checked, were Denmark and Italy, neither of which have the death penalty. And they will not export to the United States those drugs because they don't believe in it. So we've had to either try to surreptitiously get it or change the mixture. It's been very difficult. The Supreme Court has never ruled that the death penalty is unconstitutional. It's never been ruled that it was cruel and unusual punishment. But briefly, in the 1970s, between 1972 and 1976, execution stopped. The first case that kind of stopped them was Furman v. Georgia. This is 1972. The court basically said, you're not administrating the death penalty in a rational, consistent way. It seems arbitrary and capricious. Go back to the drawing board. They did. Georgia went back. In 1976, in the case of Gregg v. Georgia, the new way the death penalty was imposed was presented, basically a bifurcated trial, and the court said, okay, you can go back to killing people. Here's a breakdown for you based upon our states and countries. So since 1976, you'll notice the leader in the United States is Texas. Big surprise. Virginia's up there. It's a bit of a surprise. Oklahoma has a really fast, really, I would say, vicious death penalty statute. Florida, Missouri, Georgia, Alabama, Ohio, North Carolina, South Carolina. You'll notice that these are all pretty much southern states with the exception of Ohio. If we look at foreign, the top of the list has got to be China. We don't get very good numbers out of China. China is a very secretive society. We know they've executed more than 1,000 people in a given year. Second, Iran executes people. Saudi Arabia, Iraq, Egypt. The United States is in that list. Pakistan, Somalia. You'll notice that there's really no democracies there besides us. The Europeans, the Koreans, Japan theoretically has death penalty, but it's freakishly rare. Even the Taiwanese, the Australians, they just don't have the death penalty anymore. We're the last major democracy to routinely practice it. And I use the word routine there. So there are some limits on the death penalty. You can't execute someone who's insane, either at the time of the offense or the time of the trial. You can't execute someone who's severely mentally retarded, and that, along with this, you can't execute someone under 18, was fought tooth and nail. You really didn't have a lot of these rules in place till the 2000s. Also, the penalty is reserved from homicides. You can't impose it for almost any other offense. You can't impose it for drug dealing. You can't impose it for kidnapping. Pretty much just homicides. There is a debate about this. So, obviously, one of the issues is, isn't it more costly to keep people alive? No. The latest studies show that it costs you about $700,000 more to execute people, in part because there's more trials, there's more appeals than there are life sentences. Is it a deterrent? Our best evidence says no, it's not, or if it is, it's very slight. They've compared states that are next door to each other. They've compared the states that are farther apart. Some have death penalty, some don't. Not a big difference in the murder rate. Will innocent people be executed? I think the answer there is frankly yes. There's really no argument, because you can't create a perfect human system. So we are going to make mistakes. We are going to execute innocent people. Is it arbitrary? Yes. I mean, you can have people like Jeffrey Dahmer, who was a serial killing cannibal who doesn't get the death penalty, and then you can have someone who kills one person that does get it. So it seems a little arbitrary. Does it discriminate? Yes. If you're poor, if you're a male, if you're a minority, you're far more likely to get it. I don't think this ends it. I think that you can make an argument for the death penalty. You can say, if life is so precious, for example, the only thing that's going to balance the scale is the giving up of your own life. If we say that life is without price, then you have to give up something without price, which the only thing you have is your own life, to balance the scales. This goes back to retribution. So the future of it, execution seems to have fallen across the United States. It's difficult to get the drugs. Public opinion is split, and really for the first time just 2 years ago, in a long time, we saw that if you told people there is mandatory life sentences, a majority of Americans now will feel, okay, give them life without parole, don't execute them. But there's still a very large group in the United States that supports the death penalty. All right, on that less than cheerful note, we'll end it there, and when you're ready, you can go on to the next chapter, which I believe is chapter 12. Have a good day, afternoon, or evening.